And while she's doing that, if you guys have questions, feel free to unmute yourselves and just kind of speak during the presentation. I'm sure you guys are pretty familiar with a lot of this presentation, but if you have questions, feel free to ask, or you can put it in the chat too. And I know Sarah will be monitoring that.
Absolutely.
All right, can everyone see that?
We can see the PowerPoint. We can't see it in a presentation view.
Oh, okay. So this isn't how it was looking when I first did it with you,
Now
Sarah?
it is. Now it
Okay,
is.
okay, perfect. All right. So I'm just going to go straight into it. So the topics that we're going to be covering today are covered employees. We'll talk about the break time requirements and kind of what that might look like, how it can look really different for every person that breastfeeds differently. We'll talk about space requirements, exemptions, retaliation, enforcement, and the resources we provide. This is our general disclaimer, just to say that this is just to give information. It doesn't hold any legal weight or opinion. So if you do have questions, if you are meeting with someone who is perhaps going through retaliation or has questions, we'll have a slide towards the end where you can point them either to call me, to call our district office, or to call our 1-866 number, which is manned as well, Monday through Friday.
Anna, it looks like, and I'm not sure if it's this way for anybody else. I'm actually going to pause this.
I can go back. All right. So I went back a couple slides just so that you can have it in the recording because I guess there was a little bit of a technical difficulty with this. So the FLSA pump at work protections are pretty basic in the fact that it just requires employers to provide a reasonable break time and a private place other than a bathroom for an employee to pump breast milk. And it is for 1 year as of the child's birth, and every time that employee has a need to pump. And again, some of those things that we're going to talk about because they can look very different for different employees. So on December 29th, 2022, the Providing Urgent Maternal Protections for Nursing Mothers Act, also known as Pump for Nursing Mothers Act, or we call it the Pump Act for short, became law. And it also extended the right to pump protection to millions of workers, such as railroad workers, agricultural workers, salaried workers. So it really expanded to more than it did at the first when it first came out, which we've seen help a lot of employees. We've seen a lot more employees come forward and be like, hey, that my employer isn't doing what they need to do. And really, when we expanded it, that's when we saw a lot of this coming out. There is extended coverage that was effective, like I said, December 29th, 2022, and there were additional remedies that were available on or after April 28th. We are now past that 2-year statute of limitation, so we're only going to be talking about what remedies are available as of after April 28th, 2023. So who is eligible? Nearly all employees covered by FLSA are eligible to pump at work, and employees are eligible to pump at work for 1 year after their child's birth. Keep in mind there may be some state laws in effect that have employees eligible up to 3 years. You have to go with stricter of the two. So if you're looking at a state law versus a federal law, just know you have to follow whichever one is stricter. There are some exemptions that are pretty narrow for certain employees, a small company, and certain transportation employees, such as airline crew members, and we'll get into that a little bit later. So when we're looking at coverage, we're going to look at a couple different ways. So the first is enterprise coverage, and what we're looking at is to see whether the whole business is covered under FLSA. So we're going to look and see whether they have an annual dollar sales volume or sales of at least $500,000 a year, and 2 employees engaged in interstate commerce. That is one way to get enterprise coverage. The other way is that there are some businesses and establishments like hospitals, residential medical or nursing care facilities, schools, preschools, or public agencies that are automatically covered under enterprise coverage. They're named and they're just automatically covered regardless of their sales. So when we look at enterprise coverage, those are 2 ways that you can fit that definition. If there is no enterprise coverage, then we would look at individual coverage, and we're looking at individual employees week by week to see if they're covered under FLSA. And the way we look at that is to see if they are engaged in interstate commerce. Now, interstate commerce can be making out-of-state phone calls, receiving or sending emails, electronic communications, receiving goods from out of state. It can be swiping credit cards, because sometimes, if you work at a restaurant and the waitress slides your credit card, is going from Maine out of state somewhere to get approved and then coming back. So that's considered interstate commerce as well. And then you have domestic service workers such as housekeepers, full-time babysitters, and cooks that are normally automatically covered under the law as individual coverage. So we need to, when we're looking at whether someone or not has rights under the PUMP Act, we're looking first to see whether or not that business is covered under FLSA, because the PUMP Act is part of that. It kind of slides under that same coverage guideline. So if they are covered, whether it's enterprise or individually, the next thing we're looking at is reasonable break time. And the FLSA requires employers to allow nursing employees reasonable break time each time such employee needs to pump at work for 1 year after the child's birth. Again, the frequency and duration of the breaks needed to pump is going to vary, because especially, it can vary person to person. It can vary depending on where they are in that breastfeeding journey. Newborns typically eat, a lot more frequently than the older infants. So it can look very different depending where they are. So here are two examples. Both examples are reasonable break time. Again, if someone says they need 2 hours to pump, probably not going to be reasonable. But in this example, the first one, Irina, a shift manager at a fast food restaurant, takes 4 25 pump breaks each day when she first returns to work after the birth of her child. That it would be considered a reasonable break time. She's taking 4 25-minute breaks. She's not taking 2 hours at once to pump. It's throughout her shift. And I would guess from this that she probably works about 8 hours. And then you have Lauren, a department store delivery driver with a 9-month-old baby who needs 2 30-minute pump breaks each day she works. Again, they're very different. They're different amount of times, they're different frequency levels, but both would be reasonable and both would be acceptable under the PUMP Act. So compensation for break time. So this is a question we get quite often. And I'll just preface by saying this. If there's already some sort of break rule policy in place as an employer, they need to follow that, okay? So if they're going to be if it's going to be unpaid, they need to be completely relieved from duty. If they're not, if they're answering emails while they pump, or they're answering the phone while they pump, they need to be counted as working hours, because they are now doing work even though they're on their break time. And that holds true for any break time, regardless if it's for pumping or just a normal lunch or coffee break. If an employer provides paid break time, and if an employee chooses to use that time to pump, she must be compensated in the same way that other employees are compensated for that break time. So let's say the employer gives 2 15-minute breaks, one in the morning, one in the afternoon. Both of those are paid. And this employee, she needs 25 minutes to pump. The first 15 minutes of that would be paid. And then the second 10 minutes, or the other half, I guess, would be unpaid. And so she'd either need to clock out or document that somehow. But those first 15 minutes would be paid. Or if she only needs 15 minutes to pump, then it doesn't matter, and the whole break is paid as well. An employer must also pay for pump breaks if required by federal or state law or municipal ordinance. So keep in mind, there could be, again, some higher statute or enforcement authority that requires all breaks to be paid, depending on the industry or any unions that are in place. Space requirements. Nursing employees must be provided a space that is functional to pump breast milk. It has to be shielded from view and free from intrusion. And the space, most importantly, cannot be a bathroom. I don't know how many times we hear from employers saying, "Hey, can she, go pump to the bathroom?" No, she can't. No one wants to get their food from a bathroom, so you cannot require employees to pump in the bathroom. Shielded from view and free from intrusion. So I've seen some employers get creative with this, but generally it has to guarantee the employee's privacy. For example, by displaying a sign when the space is in use or providing a lock on the door. I can tell you from personal experience, a sign will not be enough. People will still come in even if you have a sign. So having a lock on the door just provides that extra, protection for that employee. If workers are teleworking, they have to be free from observation and have to have the ability to turn off their camera or web conferencing platform so that they can pump. And employees on passenger trains may temporarily obscure the view of recording devices when the train is not moving. So keep in mind if you have someone that is working on a train that they can't be moving. The train has to be stopped for them to be able to pump. I will say a lot of times in smaller businesses, they're like, well, we don't have like a specific place for them to pump. Like where I'm at, they do have a pump room here for mothers that they can use. But I know some places don't have that. And so we tell them often, if there's an office, you can go ahead and use, the manager's office, just while you need to pump. And they say, oh, well, there's a camera in there because that's where we keep the money. That's fine. You can turn off the camera, cover the camera, do whatever you need to the camera so that that employee is free from view and they can pump privately during that time. And then when they're done pumping, they can remove the cloth or they can, turn the camera back on afterwards. So those are some things I've seen and talked to. I see this especially in things like Dunkin' Donuts, McDonald's, kind of where things are, things are compact and there's not a lot of extra space. So the space needs to be functional for pumping milk. An employer may temporarily, this is kind of what I just talked about, may temporarily designate a space or make a space available when needed by the employee. So that would be that manager's office that I had just described. An employer should consider the number of nursing employees in their work schedules to determine whether more than one space should be designated or created. So keep in mind, if you have more than one person pumping, you may need multiple spaces, unless they work different shifts, or you can kind of have them make some sort of pumping schedule so that the room is always available for that person during their time slot. Generally, I've seen that a lot of moms have some sort of pump schedule. So they pump like every 2 hours, every 3 hours. So having a schedule or a sign up, I guess, available is also another thing I've seen that could be helpful to help employees if you have multiple nursing mothers. So an example of space, Marin, a logging company employee, pumps in a break room at the company's office. The room is shielded from view and Marin is permitted to lock the door during pump breaks. So in this situation, this space is perfect. It is private, it's shielded from view, and Marin can lock the door. So this would be an example of space that is acceptable. Undue hardship exemption. So an employer is not required to provide break time and space only if the employer employs fewer than 50 employees and it imposes an undue hardship. So I want to be very clear. This is very different. While it's similar to FMLA, it's different because there is no distance requirement in this when we talk about 50 employees. So you could have 25 employees in like York, Maine, and 25 employees in, let's say, Bangor, Maine, and that is a greater distance than 75 miles. But because together that business has 50 employees, this undue hardship would not apply. Okay, there's no distance in this situation. It's just looking at the number of employees total for the company with no distance. And then, an undue hardship, you'd have to really prove that. Okay, so it's not just because you need to put up a curtain or something like that. You have to show that it would cause something really financially harmful to your business or somehow just be completely impossible. So I just wanted to kind of talk about that fewer than 50 employees rule because it's a little bit different than FMLA. So there is an exemption for crew members of air carriers. It does not apply to crew members of air carriers. That is the exemption. It does not apply at all. And we define a crew member as a person assigned to perform duty in an aircraft during flight time. So this could be the flight attendant, it could be the pilot, it could be anyone who's doing anything while that aircraft is flying. Rail carriers and motor coaches, the pump at work protections generally apply to employees of rail carriers or motor coach services operators as of December 29th, 2022. However, coverage for certain employees of rail carriers and motor coach service operators will not begin until December 29th of 2025. So those will start this coming December. And it covers the employees that are trained crew members involved in the movement of a locomotive or rolling stock or who maintain the right of way of a rail carrier, or employees involved in the movement of a motor coach. Okay, so those are the ones that would still be exempt. There's also an exemption after a 3-year delay that is in place. Employers can qualify for this exemption that would take effect on December 29th, 2025, if they demonstrate that compliance require a significant expense or result in unsafe conditions. Again, kind of like I had said, like a significant expense would not be installing a curtain or other screening protection. That's not what we would consider an undue hardship or an extreme expense. For the unsafe conditions, obviously, I'm going to go back one slide. If these workers are maintaining the right of way or driving the train or whatnot, it's not going to necessarily be feasible for them to take that break because they have to be watching for other trains or, guiding the train itself. So we'd have to really, if someone's going to apply for this 3-year delay exemption, then they have to be able to show why it would be reasonable and necessary. And again, why it would be a significant expense. I did talk briefly about this, the interaction with state laws. Many states have laws related to pumping milk at work. The FLSA's pump at work protections do not preempt any state law or municipal ordinance that gives employer greater benefits or protections than the FLSA. Example, if a state law, like I said, has a 3-year window that they can pump, then that would supersede ours because we only have a 1-year window. Keep in mind, if someone calls us and they're 2.5 years into that pumping journey, we cannot step in at that point because our law has already expired and our statute only goes to 1 year. We would then refer them or call the state and let them know about that situation, or they can call the state and, the state would be able to handle it at that point. So prohibited retaliation, I've seen a couple of these cases. They can be a little bit hard to, and as in any retaliation case, not just pump act retaliation, be a little bit hard to prove because sometimes it's a he said, she said thing unless we have text messages or video recordings or anything of that nature. But it is a violation of the FLSA to discharge or in any other manner discriminate against an employee because, for instance, she filed a complaint to assert her pump at work's rights or cooperated in an investigation regarding these protections. Employees are protected regardless of whether the complaint is made orally or in writing. So if we get a call and someone's asking about the Pump Act or is alleging something, it doesn't matter whether or not it's orally said to us or if they sent us an email, they would still be protected. And most courts have ruled that internal complaints to an employer are also protected under the FLSA's prohibition on retaliation. So to kind of give you there's going to be an example on the next slide, but to give you a real life example, we had an employee that worked at a fast food chain and she was pumping. She needed to pump and she was moved a couple different times to different stores simply because other stores could kind of support her need to pump. But at the last store she was at, her manager told her she needed to cut her hours because it couldn't support her pump schedule and they needed people there. And so she went, I believe it was she was working 32 hours and she was dropped down to 16, 17 hours. It was a very major drop and that can't happen. And so she called us alleging retaliation. We did an investigation, did find that she was retaliated against. In a couple slides, we'll talk about, what kind of things we can do to help, make that employee whole again. But she did get back wages for that time that was missed. And I believe she was reinstated in her position. That won't always happen. A lot of times employees, if they are discharged, they don't necessarily want to be reinstated, but she did because of her own situation. So that is something that we can also push forward. So we do see it happen sometimes. We see a lot of retaliation outside of the Pump Act, just under FLSA. Keep in mind that as soon as an employee voices their rights to their employer or calls us, that is now, even if they're wrong, even if they say, I can pump for 3 years under federal law and it's wrong, they've now started talking about it with their employer. If their employer was to discharge them because of that, we would then be able to come in and possibly find retaliation. So as soon as they start talking about it or expressing it to us or to their employer, they're now going to kind of fall into that bubble of being protected under our Anti-Retaliation Act. So if you have questions, again, please feel free to ask. This is an example of prohibited retaliation. Lauren is a delivery truck driver for a department store and takes breaks to pump breast milk twice a day. The supervisor complains that the breaks are interfering with the delivery schedule and moves Lauren to a lower paying job as a result. Again, in this example, Lauren has experienced unlawful retaliation under the FLSA. They can't move an employee to a different job that is lower paying or doesn't have like the same type of schedule or benefits just because they are pumping. So in this situation, Lauren would be able to, I have messages coming on Teams. Lauren would be able to call us and she'd be able to allege retaliation. And, in this situation, we'd come in, we would probably do some back pay because we would collect the wages that she lost being in that higher paying job. And we would also, if we'd ask her if she'd want to be reinstated into that job and move and have her be reinstated. Keep in mind when we do back pay, back wages, anything like that, we generally assess also liquidated damages, which are equal to the back pay or back wages. And we can also do punitive damages. So it does become very costly sometimes for employers. And that's why we try to educate employers. We're educating, you guys are the boots on the ground right now. You're the ones meeting with the moms that are pumping right now. We try to educate moms, whether it's through you or through our booklets. That way they know their rights moving forward. So remedies, I kind of already went through some of these remedies that are available, but we'll talk more about them. So employment, that would just be, whether or not they want to go back. So reinstatement is along those same lines as that. If they are discharged, they can go back and be in that same position, or it could be kind of like in that prior slide we saw Lauren, who was kind of demoted, I guess, put it back in, and that leads to the promotion. Sometimes people are skipped over promotions because of this. So if that was ever to become an issue and they were able to prove it, we would be able to say, they need to be given that promotion. And how that looks within that company may be a little bit different, whether it's two managers or, the other manager then is bumped back down. We'd have to look. But if someone is passed up for a promotion because of the Pump Act, that would be retaliation. We can also do payments of wages lost and equal amount of liquidated damages. As I said, we can do compensatory damages and make whole relief. So we have seen sometimes where people have missed paying their rent, they've been late on their car payments, bills, whatever, because of that. So those types of economic losses, because of those violations, we would be able to get some sort of monetary relief from that. And then we've also do punitive damages where appropriate. I know for that case I talked about, I believe the punitive damages were around $2,500 plus the employee got the back wages and liquidated damages. And I don't remember how much that exact amount was, but I know the punitive damages was $2,500. So enforcement, an employee can file a complaint with us with the wage hour division or can file a private right of action. An employee always has that right to go find an attorney and file their own private right of action, or they can come to us. An employee or other party can file a complaint with wage and hour division at any time within a 2-year statute of limitations. So for most of our statutes, it is a 2-year limitation that we have. We can go back a little bit further with some of ours. But generally it's 2 years for FLSA, FMLA, pump, things of those nature. Special notification procedures may apply to filing a private action where an employer has failed to provide an employee with an appropriate space to pump. And we'll get into that in the next slide. So this is kind of something that's newer in the law that wasn't always available. So we'll talk about that. And then there's a special procedures to not apply before an employee or other party can file a complaint with wage and hour divisions. So we'd have to go through this first, potentially this next slide, before anything could be done. So what is the special notification procedures? Before an employee can file a private suit regarding an employer's failure to provide a space to pump, the employee must notify the employer of the failure and allow 10 days for the employer to come into compliance. So if they're saying, there's no space for you to pump, the employee can say, oh, you need to provide me a space to pump. I could pump here. And that would give the employer 10 days to either, find a new place for them to pump, or secure that place that the employee suggested. And the employee doesn't need to suggest anything. They just need to notify the employer of the failure. But the only time this special notification procedure is not going to apply is if the worker has already been fired for requesting a reasonable break time or space, or the worker was fired for opposing employer conduct related to Pump Act rights, or the employer has expressed a refusal to comply. So if the employee is still working there and the employer doesn't, has failed to comply, and they need to give them 10 days, and let's say it's the day they talk to them and the employer says, absolutely not, I'm not going to do this, I'm not going to comply. At that point, the special notification procedures would be off, and that employee would be well within their rights to give us a call so that we can start an investigation potentially. So this is a little bit different. This is something new that was added because this wasn't always in there that I'm aware of. So just keep that in mind now when you're talking to someone. If they've been fired for whatever reason regarding the Pump Act, though, again, those special notifications go out the window. So you're talking to a new mom and she's going through some problems at work. What can she do? So there's a couple different things she can do. She can call us at our 1-866-4-US-WAGE. That is manned Monday through Friday, 8:30 to 4:30. And what will happen is it's just our general information line. They'll go in, they'll put in their zip code, and they'll be transferred to someone within the Northeast. Keep in mind, when you call the Northeast, you could be talking to someone from Maine, New Hampshire, Vermont, Connecticut, Rhode Island, or Massachusetts. But we're all kind of considered like that Northeast corner, and those are the states that cover. And if there is a complaint that is going to be made, it is voluntary, and it is generally confidential. But in something like this, where it's going to apply specifically to one employee, we're going to ask for permission to use name. And we'll ask for it verbally. And then once the complaint is submitted and assigned, that investigator will then ask for permission to use name in writing. So keep in mind, if they want to stay confidential and anonymous, they're not going to be able to because it's affecting just them. So we will need permission to use name. And generally, if there's only one person pumping at work, they're going to know who that was. The other thing they can do is just visit us at dol.gov/agencies/wage hour division, or WHD/contact. And there's a way to email us and file a complaint that way. Additionally, I also added our Manchester district office, which is 603-666-7716, and that is also manned Monday through Friday. Hours may vary a little bit more, but I'd say anywhere between 8 and 5. Generally, someone will be there to answer the phone, or you can always email me. I did put my contact information in the chat as well. I'm often on the roads or presenting, so I do ask people, if you send me an email, expect an email back within 24 hours unless I have an out of office message up. At that point, I'll generally say when I'll be able to return an email or a phone call. There's some other really great resources available online. Fact sheet number 73 is great. I'm a huge fan of our fact sheets just because it kind of takes the law and statute and condenses it down into a way that is more palatable and digestible for a lot of people. Sometimes all the legal jargon, a lot of what the point of the message can be lost. So fact sheets are great. And we also have our facts available online as well. These are additional resources here. I haven't used any of these personally. I generally go to these before just because they're a little bit easier. But if you did need more facts, or if you wanted to print anything out to bring to your nursing moms or to employers, if you're visiting anyone, you could certainly look at this. Some more guidance is OPM's guidance on nursing mothers in the federal workforce, if you have anyone that is working in the federal workforce. And then we have some stuff from the CDC as well. If you'd like to connect with us, we do have different platforms that we're on. So you can always look for us on Instagram, X, Facebook, YouTube, or our DOL blog. And this is the time for questions. I know I kind of ran through that, but it was a quiet group. I'll stop this and just wait for any questions.
Wonderful. And thank you so much for all of that information. I felt that it was incredibly helpful because there were some things, i.e., the December dates that are coming up,
Yeah.
that I didn't know about. So thank you very much.
Yes, and I know I flew through that, so I apologize. I was like, I don't know how many questions I'll ever get, so it's always hard to know and gauge.
Of course. One question that I had just to kick things off, if you are working with a work site, for example, and they're giving a lot of pushback on policy change, what tools would you usually provide to really encourage these work sites to be compliant with state law and federal law?
So I would use fact sheet 73. I could see if I can pull that up because it's going to show that that law is in effect. And, anything from our website kind of just showing that it is the law is going to be helpful in kind of getting that employer to potentially come around. And a lot of times I find that they don't, it's not that they don't want to be in compliance. It's just that they're like, where am I going to put them? So that's often one of the things that's really hard. But I guess, showing them the law, brainstorming ideas of potential private places where an employee could pump would be helpful for them as well.
Wonderful. Thank you very much.
Yeah.
See. And what questions do other people have? Feel free to hop off mute and turn your cameras on if you do have questions.
Again, I figured they know a lot of this information, so it may not be
Exactly.
super new.
All right. All right. Well, hearing no questions at this time, I will go ahead and stop our recording, but thank you so much for presenting today. We really appreciate it. All of the minutes from this meeting and the recording will be sent out to our large group via email. You can also
Okay.
catch this recording on our HCCA website. So that is www.hccame.org. And it will be under the Healthy Eating and Active Living tab because that's where all of our breastfeeding stuff exists. But thank you very much. We really do appreciate it. That was incredibly informative.
Thank you, Sarah. And I did see your message, Vanessa, so I'm glad that this was helpful. And you too, Jessica. So if you guys have any questions, feel free to reach out at any point in time.